Thank you very warmly, Oleg, for these extremely generous words of introduction. And may I also warmly thank the organizers of the conference for their very generous introduction to me to start us all off. So when I speak, as I do in the title of this lecture, of so-called Republican liberty, I'm obviously implying a criticism of this specific theory of freedom and how it's come to be described, especially as it's become a research program in the last 20 years. You might well object, however, that all of us surely know by now what we mean when we talk about the Republican theory of freedom. So what does it matter if that is in some way a misnomer? Well, I certainly take myself to be talking to a highly expert audience this morning, and I certainly assume that all of us do agree on what we mean by the Republican theory of liberty. We are referring, I take it, to the view that what it means to be in possession of liberty is not to be subject to and hence dependent upon the power and hence the arbitrary will of anyone else. So liberty is a relationship of wills. However, I do want to say that it's a misnomer to call that a specifically Republican theory of liberty. And I also want to say that that mistake does matter for reasons of a philosophical as well as an historical kind. And so that's what I'm now going to try briefly to show. But I don't want to exaggerate, so let me begin by making it clear what I'm not saying. I'm not denying that the definition of freedom I've just offered was accepted, it was indeed universally accepted by leading contributors to the European tradition of Republican political thought. That's the view of freedom you already find articulated by the Roman moralists and historians writing at the time of the crisis of the Roman Republic and its supersession by the Principate, historians such as Sallust and Livy, moralists such as Cicero and Seneca. Livy in particular begins his history of Rome by tracing the shift from hereditary rule by monarchs to rule by elected consuls, whose mandate was just for a year and was created by an ultimately sovereign body of the people, and he describes that constitution as a civitas libera, a free state, in which everyone is able to live equally at liberty because they do not live subject to anyone else's will. They live subject to laws which they have prescribed to themselves. That's also the view you encounter, of course, in Italian Renaissance discussions of this classical Roman story, and perhaps most influentially, it's the view of libertà underlying Machiavelli's Discorsi on Livy, first published in 1531. Machiavelli speaks in his opening chapter of how some cities have the buona fortuna to be created by uomini liberi, free men, rather than by men che dipendono da altri, who depend on others. So there the liberty of free persons is explicitly defined by contrast with the condition of living subject to the mere arbitrio of a ruler, arbitrary power in the manner of a slave. Now, nor am I denying that it was largely out of those classical and Renaissance sources that the later tradition of Republican anti-monarchism in Europe emerged. This is the tradition, of course, that flowered spectacularly in France after the Revolution of '89. But I want to say that similar strands of Republican thinking had already played a comparable role in the abolition of monarchy in 17th century Britain. And I should add here that if there's a bias in my use of sources in this lecture, it is that I incline to lay my emphasis on this earlier tradition as it developed in Britain and later in North America. So I'm thinking here especially of such writers as Marchmont Needham, John Milton, James Harrington, Algernon Sidney, and the writings of the so-called Commonwealth men in Great Britain and in North America. Finally, I do not in the least deny that this tradition of thought made a distinctive contribution to the articulation of what is now called the Republican view of liberty. Let me just make 2 points here. One is that Republicans take a distinctively strong view about the relationship between liberty and the upholding of a particular form of government. And I've already cited Machiavelli as expressing it. And the slogan is derived from liberty. You can live as a free person only in a free state. That's to say, in which the will of the body politic is the will of the members of that body. If you are subject to anyone else's will, you live as a slave. But I also want to say, second thought, that the Republican writers show a special interest, this is very important in the tradition, in the psychological dimension of the distinction between living in liberty and living as a slave. They're concerned, that is, not just with the legal question of what it means to be a slave, but with the psychological question of what it means to realize that you are a slave. I mean, of course, they're writing in a slave society in which many people are born as slaves, so for a time would be a slave without knowing it. But what does it mean to come to know that you are a slave? And the answer given by the Republican writers, drawing especially here, of course, on Tacitus and Seneca, is that slavery and freedom are deeply formative of character. A free person can be expected to have a distinctive presentation. Indeed, in French and in English, the word frank used to mean free. This person will be frank, they will be confident, they will be independent of judgment. They will look you in the eye. That is the liber homo. By contrast, the dreadful but inescapable thought is slavery cannot fail to make you slavish. How could it be otherwise? Seneca particularly underlining this. Being a slave means you're wholly at the mercy of the power of someone else. But that means you're going to do everything that you can to keep out of trouble. So one of the horrors of servitude is that it cannot fail to make you servile. So in short, there's an undoubtedly significant contribution to the so-called Republican analysis of liberty that comes from specifically Republican sources, of course. Nevertheless, I still want to say that the current discussion of the so-called Republican theory got off to an unfortunate start when so much emphasis was laid on that particular tradition of thinking about freedom. The result, I would say, has been some questionable history and also some questionable philosophy. So let me turn to try to make that point. A word first about questionable history. One influential error can be traced back to a major work that greatly contributed to the renewed interest in so-called Republican liberty. I mean, John Pocock's masterpiece, The Machiavellian Moment, 1975. Pocock argues, as I'm sure you remember, that when Renaissance writers claimed that there's no freedom in the absence of self-government, they were embracing what he describes as an Aristotelian vision of political liberty. More exactly, he takes them to be embracing what he sees as Hannah Arendt's neo-Aristotelian view, namely that freedom consists in contributing to self-government. And so in Pocock, as in Arendt, of course, it's said to be because the arena of public service is the one in which you can attain the highest development of your talents, and so most fully and freely yourself. So that's what Charles Taylor, following Isaiah Berlin, has called positive liberty, although, of course, Taylor wishes to endorse it, whereas Berlin wishes to denounce it. However, as many scholars have by now objected to Pocock, Machiavelli's view of political participation is purely instrumental. As he points out in the Discorsi, if you are unable to participate, at least by representation, in the business of government, then there will be no sense in which the law reflects your will. But if it doesn't reflect your will, it must reflect somebody else's will. You are nevertheless commanded to obey it. But Machiavelli has defined the condition of slavery as in that way depending on the will of someone else. So here's the point. It is as a causal condition of avoiding servitude that Machiavelli calls for active participation in government. It's not in the least, it's nothing to do with perfecting yourself in an Aristotelian way. There's one piece of questionable history. A second confusion, I think, that's resulted from concentrating on the Republican tradition has been that while Republicans, of course, treat liberty as a relationship of wills, that's the whole point, liberty is a relationship of wills, they've never been able to agree about the concept of the will. This is not exactly a confusion, but there are two strands here. Some want to say, for example, Machiavelli, that to have the capacity for free action is to be able to act as you choose. But in the Anglophone tradition, that is very strongly questioned by the tradition which insists, I'm thinking here obviously of John Milton or James Harrington, that there should be a distinction made between liberty and license. So as these writers want to express it, if you are, interesting phrase, a slave to the passions, then you never act freely because your actions are expressions of license, not liberty. It's only liberty if the passions are controlled by reason. Well, of course, Hobbes was the man who sought to dismiss that distinction by tracing all motivations to the passion. But Kantian republicanism reinstated the distinction. And so confusion about what you might want to ask is the authentically Republican understanding of the will has been the result. Actually, I don't think either of those two confusions has done anything much to harm the understanding of the history of liberty. But the same cannot be said of the third point I promised to try to bring out. It's this. It is true that those who wrote in the heyday of Republican liberty in early modern Europe thought of liberty as absence of dependence on the will of others. But what I don't think has been sufficiently stressed is that in that era, everyone thought of liberty in those terms. I would say that way of thinking about civil liberty was not merely hegemonic, it was universal in European legal and political philosophy until it became challenged in the latter part of the 17th century. So let me turn to this story and let me first say a word about the challenge, when and why it arose. The challenge to so-called Republican liberty arose within the tradition of natural jurisprudence among those who wished to contest the legal and scholastic defense of popular sovereignty. The pioneering statement of that defense had been the work of the great Italian jurist Azzo in his debate with Lothair, major 12th century set piece about imperium. Who holds imperium? Is it the ruler? Is it the people? And Azzo's view that it is the people eventually became known as the monarchomat, the king-fighting view of sovereignty. So among defenders of absolutism in the Lothar tradition, the main polemical task was obviously that of overturning the central monarchomat claim that if you live subject to absolute power, you live as a slave. Now that task the defenders of absolutism eventually accomplished by way of arguing that the monarchomat writers confuse the state of being secure in the possession of liberty with the possession of liberty. If the anti-monarchomat writers say someone has power to restrain you at will, then your liberty is certainly not secure, but so long as they're not exercising that power, then you remain free to act as you choose. So for them, liberty is not defined as absence of subjection, but simply as absence of interference. That's the view adumbrated by Grotius, strongly affirmed by Hobbes, developed by Pufendorf, and then by his numerous followers, Buonarroti, Heineccius, and so on through the 18th century. And indeed, in Anglophone thinking, that argument entered the mainstream with a whole generation of theorists in the at the time of the imperial crisis, including John Lind, Richard Hay, Jeremy Bentham, and many others, all of whom wish to say, look, we've confused freedom with security for freedom. Freedom is just non-interference. Before that development, however, I do not find a single legal or political theorist in my reading who ever doubted the alternative view, that liberty is not being subject to the will of another. But here's the point. The vast majority of those who wrote in these terms were not Republicans. Not Republicans at all. So to put it crudely, the question we're left with is, well, where did most people get that idea from? Well, the answer is that not from Republican sources. Well, now you might say, okay, that sounds an interesting historical point, but why does that matter for us now? Well, I think it does matter for us philosophically. And if I now turn to what I think was the central tradition in which the so-called Republican theory of liberty was formulated and developed, I hope you'll see why. So that is now the task in this second half of my lecture. The body of texts to which I want to turn, I've come to feel, were probably the most influential that medieval and early modern Europe inherited from antiquity. in the field of legal and political philosophy. I mean the Codex of Roman Law, as assembled under the Emperor Justinian. Now, the Codex is specifically a body of private law, and at the start of the major section known as the Digest of Roman Law, we're told that the law encompasses persons, actions, and things. But the most important of these categories, I'm now quoting the Digest, I mean, obviously translating, is persons, because for them all law is made. So the Digest begins with a section entitled De Statu Hominum. You've got to start there, concerning the status of homines. Of course, homo in Latin meaning man or woman. What we would say is persons. Now, that analysis of what it means to be a free person proved massively influential. It's taken up by the glossators in continental Europe, beginning with the debate between Azzo and Lothair, and of course, Azzo taking the monarchical view, as I said. And then the same account of the law of persons is taken up in the 13th century into common law. The crucial text there being Bracton's massive treatise on the laws of England, circa 1240, which establishes English common law, and of course thereby establishes much law in North America too. Now, if you read either Azzo or his followers, or if you read either Bracton or his followers on the law of persons, what you find is the whole lot of them are simply quoting the Digest word for word. So what I'm now wanting to talk to you about in talking about the Digest is how the distinction between free and unfree persons entered the entire legal tradition of early modern Europe. So let me turn as briefly as I can to the section of the Digest entitled De Statu Hominum. Right here, the jurist Gaius is immediately cited for the dictum, I quote, that the principal division in the law of persons is that all persons are either liberi, free persons, or they are servi, slaves. So if you wish to understand what it means to be a free person, what you need to understand is what it means to be a slave. And here, the jurists make two crucial points. My own view is that if recent writers on so-called Republican liberty had attended to what the law says at this point, quite a lot of confusion could have been avoided. Okay, their first claim. Here I'm quoting the Digest again. Slavery is an institution by which, contrary to nature, notice that, contra natura, someone is dominio alieno subiucita. Now, dominium is the crucial term here. I don't know of any definition of that word in Latin, but it had two meanings, as dictionaries like to say, or rather, we would want to say it was used in two distinct ways, either to refer to property, dominium, or else to power, dominium. Now, here you're being told that to be a slave is to be, I quote again, subject to the dominion of someone else, subject to the dominion. So dominion here can only mean power. And if there are just two basic forms of personhood, free persons and slaves, it follows that what it means to be a free person is not to be subject to the power and hence the mere will of anyone else. Okay, there's the analysis. Let me make 2 points about it. Notice that this analysis is not presented from the point of view of the dominus who possesses dominion. The perspective is that of the liber homo, the free person who is not in subjection. In the juristic tradition, they never talk about non-domination. I think they would have found that a confused idea. They always speak about absence of subjection. As far as I can see, it was Philip Pettit who first asked us to talk instead about something he called non-domination. Now, Philip's contribution to current debates about these issues has, in my view, been matchless. But I think there are good reasons for following that, for not following that particular neologism of his. Okay, note too that the analysis in the Digest is not confined to the negative vocabulary we've become accustomed to use in speaking about liberty. The very first point the Roman jurists make about free persons is that because They are by definition not subject to the will of anyone else. They are capable, I quote again, facere libet, of doing whatever they want. That is the freedom of the free person. The freedom of the free person consists in doing what you want, unless, as the law adds, you are prevented from doing what you want, which can happen in two ways, either by law or by illegal force. By contrast, the servitude of slaves is said to consist in the fact that they never act according to their own will. That's to say, their autonomous will. Whenever they act, their actions have the character of permissions. That's what you've got to understand about slavery. This permission doesn't have to be expressed, it could be silent, but this is the permission of those at whose mercy they live, because these persons possess at all times the power to stop them from acting, should they choose to exercise it. So whenever the slave acts, it is not by the exercise of their autonomous will, but by the exercise of their will and the permission silently expressed of the will of the master. So there's what I'm calling the first of the two central claims made by the jurist, which later Republican theorists largely adopt. But then in the next section of the digest, a second claim is added about the freedom of persons that Republicans usually do not take up, although it's very important. The law goes on to say that although slaves are persons subject to the will of somebody else, not everyone who is subject to the will of somebody else is a slave. Converse does not hold. This is where the jurists introduce the category of being or not being sui juris, that's to say, capable of acting in your own right. And they say, well, a lot of people, although they're not slaves, are not sui juris. And the example they give, of course, it's a big joke in the law, is children, because the Latin word for children is liberi, but they are not fully free because they're not sui juris. They are under the power of the parents. Now, when this category is taken up into common law, it's greatly expanded. Among those now said to be not sui juris, and not just children, but also wards of court, also women, especially wives, and anyone judged to be legally incapable. In fact, into the category of not fully free fall the majority of humankind. But if these people are not free persons, but are also not slaves, there must be something further that distinguishes free persons from slaves, as well as not being subject to the will of others. So what is it? Well, the answer is obvious, and the jurists add it in their opening discussion of servitude. A slave, they say, is not just a person subject to power. Of slaves, we can also say, I quote the digest once more, in dominium nostrum rediguntur. They are persons who have been reduced to being our dominion. And here, grammatically, dominion can only mean property. They've been reduced to being someone's property. So the definition of slavery that emerges from the Roman law text is that to be a slave is to be wholly subject to the power and hence the arbitrary will of someone else in virtue of being in their ownership. Okay, that's as quick as I can be in giving an outline of the juridical way of thinking about civil liberty. And I want to draw this talk to an end by making three comments on it. The first will be historical, the other two are more philosophical in character. First, the historical point. As I've said, the tripartite distinction drawn by jurists between being free, being a slave, and not being fully sui juris is one that Republicanism doesn't particularly occupy itself with. They tend to operate between just the binary distinction, being a free person or being a slave. But here's my point. We really must not follow the Republicans here. As began to be pointed out when the debate about slavery became vociferous in the course of the Enlightenment, that's to say that anyone who is subject to the will of another is a slave. But that is to inflate the category of slavery to a morally outrageous degree. And that's a point of the greatest importance to abolitionists at the time, because this happened during the imperial crisis, Great Britain and its colonies in America in the 1770s. The original grievance voiced by the colonists, as you know, in 1765, was that they were being taxed without representation in the British Parliament and hence without their consent. So they say the demand for taxes is being made in the form of an exercise of arbitrary power, but that means that we are slaves. But even at the time, that argument caused outrage. I quote one of the leading early abolitionists, Dean Tucker of Bristol. Here are people who own slaves claiming to be slaves. Can they not see that the difference is that a slave, unlike George Washington, is not merely subject to someone else, but is in that condition in consequence of being their property? The colonists may have a case, Tucker says, but it's not that they are slaves. Okay, now I end with my two more philosophical comments. The first is that it would have been very good if those who'd led the revival of discussions about the so-called Republican theory of liberty in the 1980s and 1990s had made it clear, which they failed to do, that as the jurists had always insisted, the core idea is being a free person. That's what the law wants you to understand. What being free is all about is being a free person. If we had really held on to that thought, it would have neutralized an objection to the so-called Republican theory that keeps being raised. It never seems to go away. And here is the alleged difficulty. According to Republicans, freedom can be defined as non-domination, simpliciter. So you have to say, I mean, here I quote Philip's original formulation in his 1997 book, acts of interference may condition but do not take away liberty. Well, that's unfortunate because it lets people say, and they keep saying it. I mean, for example, I quote a recent article by Professor Tallis, you cannot say that interference is never sufficient for a loss of freedom. As he goes on, this is his example, I hasten to say, it seems an obvious deprivation of my freedom if someone restricts my movements without my consent, for example, by handcuffing me while I am lying asleep. Okay, the outcome of that line of criticism has been, of course, as you'll know, the suggestion that for a satisfactory account of freedom, you're going to have to put together the concept of domination and the more familiar analysis of freedom as absence of interference and somehow combine them. Now that's a project that even so major a theorist of Republican liberty as Frank Lovett has felt obliged to devote a lot of time to. But what I want to say is that I think that Philip Pettit's original formulation, which he has since amended, it's important to say, and that of his critics, both go astray. And that the right solution is in the jurists. You have to see that the fundamental question is, what does it mean to be a free person? And as we've seen, it means being able to act according to your autonomous will, in virtue of not being subject to the will of anyone else. So you have to distinguish between restrictions which have taken away your standing as a free person from restrictions which, although they limit freedom of action, leave your standing as a free person untouched. Now, a free person who suffers some act of physical interference obviously forfeits some liberty of action, but that does nothing to take away their status as a free person. By contrast, a free person, subject to the will of anyone else, as we've seen, wholly loses their freedom of action altogether. They never act freely. And what the defender of Republican liberty has to say at this point is, look, what matters is your status as a free person. Compare with that interferences with individual actions. That's really vanishingly small significance. What freedom is a relationship of wills. And what that also means is that it is the name of a status. Freedom is the name of a status. It's not a predicate of actions. And the status which it names is the free person not subject to arbitrary will. Okay, my other, and this is my concluding philosophical comment, is, I think, a further way in which it's been unfortunate that the current critique of theories of freedom as non-interference has been formulated in Republican rather than juridical terms. Now, this is a complex point I want to make, just to make it as simply as possible. Both the juridical and the Republican traditions of thinking about liberty connect freedom with rights. But in recent discussion, the emphasis has tended to be placed on the Republican rather than the juridical understanding of what it means to speak of a right. Now, why is that unfortunate? Not just because it's unhistorical, although it is, and that's always unfortunate, but because there's a case for saying, and Lena Haldenius has been recently making this case really impressively, that as Republicans, we may have left ourselves with the wrong theory of rights by attending to the Republican instead of the juristic tradition. So let me just end by trying to make good that claim. The first point that needs to be made is that many Republican theorists of liberty, of course, operate without a concept of rights at all. I mean, I'm going to set aside that point in a moment, but that's very important. This is true of all the classical theorists. I don't think you find the notion of a subjective right in classical moral philosophy at all. And it's certainly true of their Renaissance admirers. There I feel on strong ground. I mean, a writer like Ricciardini or Machiavelli operates entirely without the concept of a right. Diritti, the rights, it's present in the Italian language at the time, they never use the term. They just don't talk like that. Well, of course, that gave rise at a certain point in recent discussions to the view that the Republican tradition is hostile to the discourse of rights. But anyone who studied 17th century Republicanism, such as Christopher Amell, for example, have had no difficulty in showing that that's by no means true of that period. Of course, Republicans talk about rights. And indeed, if we now turn to the great Anglophone figures, John Milton or Algernon Sidney, or indeed John Locke, they all speak not just of rights, but of natural rights, rights of nature. And that stress on natural rights remains central to the English Republican tradition right through the 18th century, which might be said to culminate in Richard Price's tracts on civil liberty in the 1770s, as well, of course, as having animated the American Revolution of the same years. As Price explains, I quote, "We are all endowed by God with certain rights or liberties of action that we would equally possess in our natural condition outside civil associations. So these rights are universal, they are said to be inalienable, and they are susceptible of providing a moral evaluation of political associations, which are enjoined to uphold these rights on pain of losing their legitimacy. So they must be treated as inviolable liberties." This is what has come in current parlance to be called human rights, rights of nature, rights of humankind. So, as that suggests, within certainly Anglophone philosophy, it would be fair to say that that analysis has remained the dominant way of thinking about civil and political rights. Your rights are viewed, that is, as possessions that you would hold outside the confines of any particular political association. And they take the form, here's the key point, of universal moral demands. They can be made by everyone upon everyone else. But the point I want to stress is that this is not in the least the understanding of rights that you find in the juridical tradition of thinking about Republican liberty. Once the law of persons, as articulated in the Digest, was taken up, originally, as I've said, via Bracton, into the Anglophone tradition of common law, in which law is defined as reasonable custom, a completely different view of rights begins to emerge. They are seen not as natural moral properties, but as bodies of custom and precedent that have grown up over time within specific political associations and have survived because of their social utility. So they're enshrined in law, not because they are God-given properties, but because these arrangements have been tested by time, and that has disclosed their enduring social usefulness. Now that, for example, is the view of the British Constitution you find in the writings of Sir Edward Coke in the 17th century, and of course, Edmund Burke a century later. These rights are not denied as being ones that would cause you to forfeit your status as a free person if you lost them, but they're not rights of nature. They're not natural rights. They're what these writers like to call, and Coke I think, coined this phrase, fundamental rights. I find that vocabulary first introduced, indeed, as far as I can see, with great suddenness, into the English language by the parliamentary opposition to the British monarchy just before the outbreak of the civil wars in 1642. You find the complaint that fundamental rights are being undermined by the Crown, by its exercises of arbitrary power, in the Petition of Right, which was drafted by Sir Edward Coke. The objection already voiced in the petition is executive action is leaving the people subject to the mere will of the Crown. But to be subject to the mere will of anyone is to live as a slave. So underlying that complaint, you can already hear the litany that was explicitly voiced in the British Bill of Rights of 1689, which remains statutory in my country to this day. As the bill declares, there are some rights established by custom as so fundamental that they must be placed beyond the power of government to challenge. And of course, courts are there to insist on that, as they had to do in 2019. This is beyond the power of mere government to challenge these rights because they are fundamental. They're beyond legislation. And according to the bill, there are three such fundamental rights: the right to life, and hence self-defense, the right to personal liberty, that is habeas corpus, and the right to hold and dispose of property, including, crucially, property in your own person. Now, those are fundamental rights and so fundamental liberties of action, but they're never called natural rights, nor are they in the Bill of Rights. And in Burke, of course, the very idea of natural rights is subjected to denunciation. The whole point is, this view of rights is that they are a social construct, not a natural construct. They are encapsulations of what one specific political association has recognized as essential to the fulfillment of their basic purposes. So the status of being a free person on that account is the Old English idea of the freeman. It is equated with the capacity to exercise freedom of choice without possibility of interference in relation to those fundamental rights. Okay, you might say that's just an historical point, but I would say that in the history of moral and political philosophy, there's no such thing as just an historical point. The history of moral and political philosophy is full of paths not taken, concepts set aside. We always need to ask ourselves if they've been set aside for good reasons. That's to say, philosophically good reasons, and not just for ideologically sufficient ones. And whether it might not better suit our moral purposes to use those abandoned concepts than the ones we currently employ. Well, that, of course, was the thought that underlay the current revival of the Republican conception of liberty. And as I say, I strongly agree with Professor Haldenius that we also need to ask ourselves if we might not do well to reconsider the understanding of rights that originally accompanied that view of liberty. So the question is, should we adopt a view of Republican liberty which is juridical through and through? And that's the question I want to leave you with. Thank you all very much.